All right. Well, welcome everybody. I'm attorney Peter Harbach from Hooper Law Office, and this is our weekly noon seminar. Today's topic is going to be on the Secure Act, and the Secure Act is huge in the estate planning or financial advising realm, but didn't get quite as much sort of publicity as I would have expected. But we're gonna work our way through it. Primarily, the people who are going to be interested in most of this information are those of you that either presently or intend to be putting investments in retirement accounts. So there's a whole gaggle of changes. A couple of little housekeeping things before I get started. If you're registered for this class on Zoom, you're able to ask questions, and please ask them as we go here. I'll try and address anything that, either if I'm being unclear or not covering something that you're hoping to hear about, I'll do my best to respond. In addition, our next class is going to be September 2nd, also at noon. So that's another Wednesday at noon. And next week's class is actually going to be on planning options for taxable estates. So there's a lot of estate tax planning things that aren't really public knowledge or generally well known by the public. And so if you have an estate that you'd be concerned about the estate tax applying to you, probably a good class for you. And then the last thing I want to mention before we get started here is we're also hosting a drive-in movie event at the Field of Streams in Freedom on September 22nd. So if you have any interest in seeing that, gates open at 6:30. There's going to be a comedian at 7:30, and then the movie starts at 8. And the movie's going to be Secondhand Lions. So if you want more information about that, you can either go to our Facebook page, because we have a bunch of posts about it there, or you can go to healthyagingevent.com. And that has information also about registration. The event's free. We're trying to support something that gets people kind of out of the house, but able to socially distance and have a little bit of fun. So it could be a real fun event. Registration is required, so we know how many people we have to prepare for. But like I said, it's free. So if you got nothing going on September 22nd that evening, come on out. We'll be there, and it should be fun. Okay, so let's jump into our topic here, which again is the Secure Act. The Secure Act got passed into law the very end of December of 2019 and became effective January 1st of 2020. So everything that I'm talking about here has no application if somebody passed away and you've inherited an IRA from them, if they'd passed away before this year. So if, for instance, you've inherited an IRA or are soon to be inheriting an IRA from, a loved one, or somebody passed away in 2019 or earlier, this does not change the timetables for you to take withdrawals or anything like that. It was not retroactive in its application. It's just 2020 going forward. So obviously, if you're watching this, you're still alive in 2020. So the big thing for you is to make sure that your own estate plan is properly aligned and you've taken into consideration these new substantial changes in the laws, because a lot about IRAs have now changed. Before I start talking about the Secure Act, I should also mention that there is the CARES Act. And the CARES Act is kind of a coronavirus relief act that got passed this year, earlier this year, this spring, in sort of response to COVID and some of the financial implications that Congress sort of anticipated might be happening to the public because of COVID and the pandemic and layoffs and things like that. So everybody should know that if usually in a year you have a required minimum distribution, meaning you're old enough to have to take some amount of money out of your retirement accounts. This year, there's actually an exception to having to take funds out of your pre-tax retirement accounts. So if you've not yet taken an RMD this year, you're not required to. I'm not saying that makes it a good idea to not take out some amount of money, but you don't have the requirement to do that. So you might want to have conversations sometime this year with either your financial advisor and or CPA to make a determination of, well, okay, I don't have to take anything out of this retirement account this year, but should I for tax planning purposes? So that's one thing to consider. Also, if you have had either COVID or a substantial financial burden because of COVID, like if you were furloughed, let go from your job, you're on unemployment and you need access to funds, there is an exception to the penalty also if that applies to you, which means you would not be hit with the extra 10% penalty if you're underage and have to access your retirement accounts early, and the age is 59 and a half. There's no penalty, but remember, it's still taxable assets. So when you take the funds out, you're still potentially paying income tax on them. So it doesn't make the receipt of the funds, tax-free or anything like that. You just don't have the penalty. And then there's also options for repayment over the next couple of years to put the funds back into an IRA or 401k. I believe the limits on what you can pull out is $100,000. But I would, if you were considering doing something like that, I would check with your IRA custodian, financial advisor, CPA, to look more specifically into that. Also, if you were to be returning funds, you would very likely would have to amend your tax return because you would potentially be returning funds in subsequent years after you already filed your 2020 income taxes. But this is just general knowledge, knowing that that's out there. Okay, so back to the Secure Act. Like I said, Secure Act passed very end of this year, and it affects people who pass away 2020 and later. So one thing that affects people who are still alive is it used to be that the age of required minimum distribution was the year you turned 70 and a half. So when you put money into a pre-tax retirement account, the deal you've basically cut with the government is, all right, well, I'm putting money in here and contributing to this. You're not going to tax me on this. But then I'm going to be required to take it out starting the year I turn 70 and a half. And when I pull it out, it's going to be taxable income to me here. Well, the mentality behind this is, well, while I'm working and likely contributing to this IRA, 401k, whatever, I'm probably in a higher tax bracket because I have all my work income. And then maybe once I retire, maybe I'm in a lower tax bracket because I don't have all this work income anymore. And so when I take the funds out, they've grown tax deferred in pre-tax. But now when I take these things out, I'll get taxed at whatever my income tax bracket is at that time. But of course, if you take out a lot, that's all ordinary income that you're taking out. And so that could actually push you into a new income tax bracket. So people, of course, need to be somewhat careful about the timing of these distributions. But again, it used to be that the year 70 and a half, you had to start taking some money out. And it was based on an actuarial table and your life expectancy. And they actually pretend you're married to a spouse who's 10 years younger than you, unless your spouse is even younger than that. Then you can use sort of a combined life expectancy for your withdrawals. But that has only changed in that now the age of required minimum distributions is the year you turn 72. So they pushed it up and let you defer when you take your required minimum distributions. You can always have accessed that money earlier and without penalty, so long as you're at least 59 and a half. So it doesn't mean that it's smart to wait until you're 72 to touch any of the funds. even if you don't need to be spending it, because some of this is, okay, what's my overall strategic tax planning that I should be doing? Because waiting is not always what's best when it comes to what's the most strategic tax planning. How do I whittle away and have a good game plan for the taxation on this asset, since it's maybe a majority of my savings for retirement, or what I own. It might be, maybe it's all of what I have. And so timing it and doing some strategic planning there is very important on, okay, when should I withdraw this to minimize the taxation of it? And again, just waiting as long as possible to pull out of those funds is not always best. So here's the biggest change in the Secure Act as to how it affects estate planning. Well, under the old law, when somebody passes away and they leave it to, let's say, their kids, under the old law, the children had their entire life expectancy to take out of retirement accounts and get taxed on them. Because the pre-tax nature of an IRA, the fact that the tax is still due on it, does not disappear when you die. You don't get out of taxes even though you might have passed away on those IRAs or 401ks. The tax burden is essentially transferred to the beneficiary, the recipient of this IRA or 401k. So it used to be that they had their whole life expectancy to take out of this thing. And so if you had a child who was, say, 50 years old when they inherited, they might have 30 plus years to take out of this IRA and use the required minimum distribution. Nothing necessarily prevents them from taking more out. There was just a minimum that they had to take out over that period of time. And so if you have 30 years, or say you had a 10-year-old who was inheriting, they might have close to 70 years to take out of the thing. You can do a lot of strategic tax planning there. And the Secure Act has essentially done away and killed off what's referred to as the stretch IRA, the ability to stretch out the income tax burden over a long period of time, which, for tax purposes is very unfortunate for those of you who have allocated a lot of funds to, pre-tax retirement accounts, because you might have been doing so, with the knowledge of, okay, when I pass away, this is how the tax works. So this is how I'm planning for my family. But they upended all of that and undid the ability to do a lifetime tax stretch for most individuals. So what happens now is, for beneficiaries, unless there's something called eligible designated beneficiaries, the people have no more than 10 years to take out of these inherited retirement accounts. They no longer have required minimum distributions. The law basically just says, okay, within 10 years after the year of death of the account owner, all of the money's got to be out of that IRA. Can't have anything left in there, which means you have no more than that period of time to take out. So you can choose, well, I'll take none out this year and a huge chunk next year, and then I'll leave it be for 4 more years. They can choose when it comes out, but it all has to be out within those 10 years. And so that's a huge difference, because, let's say that 50-year-old who had inherited under my other example, let's say that person inherited an IRA in 2019. Well, if they're only having to take out, 3-4% of the account balance initially, and they're probably working and hopefully maybe even earning the most they've ever earned in their careers, because they've maybe been working for 20 years by that point or longer, and they've kind of hit the pinnacle of their careers, and they're in the largest accumulation phase of their lives and have the most income. Well, if you just had to take out a few percent of an inherited IRA, all right, no big deal, because you're deferring the taxation on a lot of it. And then you could have been taken more out maybe after that 50-year-old retires 10 years later. But now, if they've only got 10 years to take it out, essentially what Congress's goal here was to force more out of these IRAs, because the quicker funds have to come out of the IRAs, that means these larger sums get taxed, and that's a raise in revenue. I mean, nobody described the Secure Act this way, but it's a way to raise more tax revenue for the government. I mean, that's just what it is. It's basically impossible to argue that the death of the tax stretch on inherited IRAs was intended to do anything but that. So now when people are inheriting these IRAs with this shorter timetable and they have to pour all of the assets out, that has a big effect on them, obviously. I had mentioned that the majority of beneficiaries have this 10-year timetable, except for eligible designated beneficiaries. And this is kind of a special class of people. So like if a spouse inherits an IRA, they're not stuck with that 10-year timetable. If they got the IRA from their spouse, they can either keep it as a beneficiary IRA and still use their life expectancy, or, and this is the most common thing that most spouses want to do, they can do a spousal rollover and essentially be treated as though they were the original earner of that IRA or 401k money. If there's a disabled child exception. So if you have a child that had a disability and is unable to work, that child potentially is covered as an eligible designated beneficiary and may be able to use their life expectancy. Minor children actually get until the age of majority. So for instance, a 10-year-old can have an extra 8 years as a minor, and then they've got the 10 years after that. So potentially a minor essentially could go up to age 28 in making withdrawals from an inherited IRA. And then another exception, and this is a weird one, it's if you're leaving funds to beneficiaries who are no less than 10 years younger, no more than 10 years younger than the decedent, the owner of the IRA. So for instance, if an individual left an IRA to their brother, that brother is not necessarily, who's 3 years younger, let's say, is not necessarily stuck with the 10-year rule either. But notice that it was only minor children that were accepted. And so the most common things that I tend to see my clients want to do with their IRA is to either leave it to their kids, or in some cases, leave it to their grandkids. Well, if the kids are adults and aren't disabled, there's no eligible designated beneficiary exception for them. They're going to have the 10 years. That's by far the most common thing people tend to want to do with their IRAs. With like minor grandchildren, it used to be really nice strategic planning in a lot of cases because they had a nice long lifetime tax stretch under the old laws. So a lot of times we were leaving IRAs, and in particular Roth IRAs, to young people because that was nice strategic planning for them. But if they're minor grandchildren, that's not a minor child. It has to be the adopted or biological legal child of the person in order to qualify as an eligible designated beneficiary minor. So that's not going to work either. So again, the most common thing people have a tendency to do is they leave their assets often in equal shares, sometimes not, but just the most common plan I have a tendency to hear from a client is, I want to leave it to my kids in equal shares. And, if my client's 70 years old, the kids are almost always adults by that point. So absent a disability, those kids are going to have 10 years to take out of these funds. So that is a big issue. And there's a number of key things that people should look at in addressing this kind of stuff. Number one, if you have a trust-based estate plan, they're often very, very good plans. There's many reasons why you might use a trust in your estate plan. But if you did this under the old laws, meaning you did it prior to this year, you probably have your IRAs going into that trust for numerous reasons, but most notably so that the terms of your estate plan are governing these IRAs. And there's a lot of misinformation out there, especially from uninformed financial advisors, about how like a trust would hurt the tax stretch. Not if the trust is written correctly. You can get the same darn tax stretch in a trust as you can not using a trust. So it's very neutral to that point if they're done correctly. But the reason you might be having the IRA or 401k go into the trust is you want terms of your estate plan to actually control the trust, either asset protection for a beneficiary or multiple beneficiaries against things like, divorce or creditors, bankruptcy, medical costs, things like that. Or you want to exhibit some amount of control over these funds, either because maybe you're leaving it to a young person or somebody who doesn't have, great financial decision-making ability, or somebody who has a substance abuse issue, where you feel necessary to provide some amount of kind of checks and balances over the money. Trusts can be wonderful for all of those types of things. But it's at least possible, if not probable, that you might have in your trust terms that essentially say, okay, well, any withdrawal from the IRA is required to go right out to the beneficiary. And the term often used for that is the trust being a conduit trust, meaning it's just this mere vessel to send withdrawals from the IRA out to the beneficiary. And those were very common because they're very simple to administer. It provides the trustee some discretion, but it's very easy to maintain that tax stretch over the person's lifetime. And most of the things that you're trying to accomplish in many of the instances where you're having an IRA go to trust, it's very simple to do that through a conduit trust. Well, the issue here now is if you've got an IRA and you still have a conduit trust, I know you're still alive because you're watching this, so that means you didn't die under the old law. Well, now in the new law, that means that the IRA all would have to come out of the trust in 10 or less years, which means if you were trying to do this for control or asset protection or whatever for these beneficiaries, it's going to lose all of the assets that are in that IRA. It's not going to be in the control of the trust for any longer than 10 years. And so it's very common that somebody is going to want to, if you have terms in your trust to control your IRA right now, you're going to want to modify those terms to be using accumulation provisions, which basically say, okay, trustee, you're obligated to still take the money out of the IRA in the appropriate timetable. However, you're not forced to spend it out to the beneficiary. It doesn't have to go right through the trust and into the beneficiary's hands. You can exhibit a greater amount of control over this. And so that means that after 10 years are over, there's a possibility, depending on the decisions of the trustee, that maybe a substantial amount of the funds are still within the terms of the trust and still have the protections and all the nuances that you put in that you're hoping to accomplish for your estate plan. So it's just important to understand that if you have a trust-based plan, and if you have what you would consider a substantial IRA, and there's no set dollar amount. It's, hey, do I have a chunk of money that I'm intending to have go into my trust that is from IRAs that isn't just a tiny, like, you probably wouldn't get too fancy if you've got a $10,000 IRA. But if you got a bunch of money or a decent sized percentage of your estate is IRA, this has a huge effect on you and a huge effect on the appropriateness of the terms of your trust. And so this is something that you need to look at with either your current estate planning attorney or a new estate planning attorney. You got to get this addressed because it has an enormous impact on the family. So I'm getting a little low on time, so I'm going to get into a couple other sort of considerations in this. Number one, something that people are very actively doing right now in managing tax brackets because of the tightening around the Secure Act for their beneficiaries' timetable is they're looking at doing Roth conversions during their lifetime, chipping away at some of the taxation in their IRAs or 401ks at a reasonable clip so that there's no tax bomb going off at their death where a whole bunch of income is just going to get taxed to the beneficiary in a very short period of time. So you'll want to probably talk to your financial advisor, CPA, about, hey, is it appropriate for me to do Roth conversions? And they're going to want to know, oh, what's your tax bracket? What's your kids' tax brackets look like? And then you can kind of weigh out, okay, how are we going to make sure that the smallest amount goes to Uncle Sam? I've never had a client say, I want to pay more in taxes than is absolutely necessary. But I've had plenty of clients say, I want to minimize the taxes as much as I can in order to get as much value to my family as possible. And so Roth conversions can be a really helpful tool in that. They're not a magic bullet, but they're something that a lot of people are seriously considering because of the Secure Act. In addition, you might be looking at your individual circumstances and your beneficiaries, and you might be reassessing who gets what if potentially some of your beneficiaries might be eligible designated beneficiaries, these people who have a different timetable to take out of IRAs. So you might be shifting around and working with the estate planning attorney to determine what assets are going to be best to allocate to which of your beneficiaries. Addition, two other things that can be helpful is considering life insurance as a component of your estate plan, because if you're paying life insurance premiums and you have this pot set aside, and maybe you're taking money out of your IRA to do that, so you're getting taxed on that at a slower clip. Life insurance money is not taxable to the beneficiaries upon their receipt. So in some instances, the math can play out well where, okay, I'm going to buy some life insurance, allocate funds to that, chip away at the taxation on the IRAs here, and then make sure my family gets this tax-free benefit upon my passing. And the last thing I want to quickly mention is there's a concept called charitable remainder trusts. And if you're charitably inclined, I think that's sort of consideration number one. I don't much care for charitable planning if you don't actually have any charitable intent. If you think this is just going to be a huge money saver, it's probably not the best tool for you. But if you are otherwise charitably inclined anyway, a charitable remainder trust can be a really wonderful tool. If maybe you want something to go to this charity, but you also want to provide maybe lifetime income to one of the kids. Or maybe all of the kids. So you could leave your IRA into a trust, and it has to have a number of appropriate terms in there. As an example, it has to pay out at least 5% every year in order for it to qualify. And so you leave your IRA to this charitable trust. The receipt of that IRA in a lump sum doesn't cause any kind of taxation whatsoever. And then the trust pays out to one or more beneficiaries, either for a term that's not greater than 20 years or maybe their life expectancies. And so it pays out over a period of time. And when they receive it, it's going to be taxable income that they receive, but it's stretched out. It can go for 20 years. And so that's a lot longer than just 10 years. But then after they pass away or the term is over, the remaining money in that trust goes to the charity or charities that you've named. So that's CRTs in just a 2-minute nutshell. But I just want to give a flavor for all of the different planning that is available to sort of address the Secure Act, so that you have a sense of what can be done. There's one question here, which is, I'd imagine conduit trust is more expensive to monitor and maintain. Well, the answer to that's not necessarily. When you're establishing a trust, you can choose who you want to be the trustee of that trust. And so if you are making for instance, the beneficiary also the trustee, then there really aren't any outside administrative costs. Now, you'd want to have a beneficiary who's capable of doing some tax monitoring and understanding some rules, but if you're trying to keep costs down and you got to say a responsible beneficiary, they're capable of handling that in most instances. Every trust that inherits an IRA is going to either be a conduit trust or an accumulation trust, sort of by definition. Conduit trusts are actually probably simpler to administer than accumulation trusts on average, because essentially they're just, the trustee is receiving whatever they pull out of the IRA and sending it right out to the beneficiary. So it's not a complicated management, really. So hopefully that answers your question. So, if you're paying an outside source, obviously they're going to be charging for it. But if you're using family members or they're being their own trustee, then maybe there isn't any payment being made. And another question, what's the best way to review our estate plan to include what we've discussed? It's created back in 2017. Well, in terms of reviewing an estate plan, I can tell you what our process is. When we are making appointments with clients, we ask for their estate planning documents if we're not the ones who drafted it ourselves. If we were the drafters, we have copies of it already. So we just, somebody calls our office, we schedule an appointment, go through the estate planning documents together, kind of talk about what the changes in the law are, what the changes of the circumstances might be for the client, and how's your health, how are the kids doing, have you moved a bunch of money around? We want to, of course, make sure that beneficiary designations are still pointed in the right directions, because an estate plan can be perfectly written, but if it doesn't end up receiving the assets correctly because of a client moved financial institutions and then changed the beneficiary designations and weren't thinking correctly about their estate plan, the plan won't work correctly. So we review all of that sort of stuff. These days we're doing most things by Zoom meetings like this one, or by phone. But in a nutshell, it's just, if you were to be working with us, you just call the office and we send out a little packet of information and schedule a get together. If you have a separate estate planning attorney, and anything that we've talked about, there's no requirement that you go back to that same attorney, but if you liked working with them, I really encourage you to review your own estate plan in whatever manner, whether it's with the previous attorney or our firm. Just use this information. Don't just listen to it and think, oh yeah, I learned some stuff. Take action to have this stuff help your family. I mean, that's what my goal is in teaching these. If you have a decent amount of retirement accounts, whether they're Roth or a traditional IRA, the Secure Act has really been a game changer for you, and you need to address this in your estate plan for everything to work ideally for your family. Okay, so I think I made it through everybody's questions. So I really appreciate everybody's time. As a reminder, our next class is going to be on taxable estate planning. It's going to be on September 2nd, also at noon. You can register that either through our Facebook page, or I believe the website for it is estateplanningseminars.com. Nicole, is that correct? Estateplanninglive.com. So if you go to estateplanninglive.com, you can register for the next seminar. We're going to be off the week after that. So on the 9th, there will not be a class, but then we're going to be returning for subsequent courses. So, I really hope you have found this to be useful, and, a good use of your time. In the summer, I try and definitely give good information, because we have to relish those warm summer days here in Wisconsin. So I hope you found this to be useful for your time in giving up a nice summer day. And if you need to contact us, if I talked about things that you feel are really pertinent to your own situation and you don't already have a estate planning attorney that you're working with on these things, feel free to contact us and reach out. We do initial consultations without charge to just understand what somebody's situation is and what we might want to do going forward. So, feel free to reach out to us, but otherwise, just do something with this info, make it worth your time. So thank you very much for your time. Have a great rest of your day, and I hope to see many of you next week.